My name is Colin Standish. I'm leader of the Canadian Party of Quebec, la Partie canadienne de Quebec. We're here to discuss a very significant issue, Bill 96, its effect on Quebec, the whole of Canada, and as well talking about disallowance and what the federal government can do to prevent the oncoming disaster that will happen as Bill 96 is fully implemented. The status of Quebec since June 1st, 2022 heralded one of the most fundamental shifts in our country's history. Yet, no fireworks, one-gun salutes, or grandiose displays of patriotism signaled this event, and for good reason. Bill 96 incorporates hundreds of changes to our daily lives. Violating Bill 96 can result in up to $90,000 in fines. As an employer or client of a business suspected of violating parts of Bill 96, your cell phone, computer, and personal papers can be seized without a warrant. Young adult Quebecers no longer have the right to register at the cégep of their choice. However, what does it all mean beyond the laundry list of new restrictions and obligations? Bill 96 is more than a language law, and indeed is the most profound restructuring of our country since the adoption of the 1982 Constitution Act. The party, the Canadian Party of Quebec, that is, submits that Bill 96, a proposed modernization of the Charter of the French language, redefines and restructures Quebec's and Canada's legal structure in fundamental and illegitimate ways. It institutes a primacy of French language above all other considerations in law and governance. The linguistic reengineering is incompatible with individual rights, natural justice, human and civil rights, national unity, and a bilingual country called Canada. The party notes that Bill 96 contains over 200 amendments, which include, firstly, vast search and seizure options, restrictions on who's entitled to receive government services in the language of their choice, an English cégep enrollment quota for high school graduates to coincide with a 10-year freeze for English-speaking cégeps announced in 2021, a deliberately discriminatory and misleading definition of who is an English-speaking Quebecer. The bill also seeks to eliminate the bilingual status of 50 of 89 municipalities across Quebec. Public notices will no longer be published in English, and bylaws will have no official status in the English language. Taken in its entirety, the Canadian Party asserts that Bill 96 is a fundamental and illegitimate restructuring of Canada's constitutional order. In addition to government's norms within the province of Quebec, it redefines the relationship between citizens and the state, and between individuals in Quebec, with negative implications for all. Bill 96, if enacted, and when it is currently being enacted, will erode, erase, and extinguish the fundamental freedoms of all Quebecers, be they French speakers or English speakers, newcomers or First Nations or Inuit peoples. The bill deliberately disinstitutionalizes and delegitimizes the English language and English speakers in Quebec to the detriment of all residents. Despite long-standing perceptions to the contrary, English speakers are socioeconomically disprivileged. The English-speaking community today is a declining population, an aging population, and burdened by the missing middle, with lower proportion of people aged 15 to 44, and a missing out middle, meaning working-age people on average have lower levels of income and employment than their French-speaking counterparts in Quebec. The party's objections to Bill 96 are summarized below. Bill 96 does not promote, protect, or increase the French language usage at home, will not increase the number of mother tongue francophones, nor increase the percentage of Quebec residents with French as their first official language. Bill 96 effectively erases English as an official language of Quebec at the provincial level. The presence of English-speaking institutions and individual English speakers from civil society and public administration in the province of Quebec. The proposed unilateral constitutional amendment is in itself unconstitutional and ill-advised public policy that will affect other parts of the Canadian Constitution. Changes to Bill 101's interpretive framework, the Quebec Charter of Human Rights and Freedoms, and the other provincial laws will distort fundamental freedoms and human rights. Freedom of expression, commercial expression, work and employment, contractual liberty, and educational freedom are further constrained, for all Quebecers regardless of linguistic group. Bill 96 provisions further impose the province's expanded language bureaucracy into a relationship between professional orders and their members with negative consequences for said members, their professional obligations, and for the public good. The use of provincial and federal notwithstanding clauses will suppress basic rights and freedoms for all Quebecers in extreme and illegitimate ways at home, at school, the workplace, and in commercial transactions. The unconstitutional aspects of Bill 96 fundamentally alter our society. The main reservations of the party revolve around three main themes. Firstly, Bill 96 is a fundamental and illegitimate restructuring of our society. Secondly, Bill 96 surgically excises the English language, speakers or institutions, and associated human rights from Quebec. Thirdly, Bill 96 diminishes the civil and human rights and fundamental freedoms of all Quebecers, regardless of mother tongue, official language preference, and ethnic background, in particular the rights of Quebec's First Nations and Inuit communities. Additionally, the proposed legislation will institutionalize the right to discriminate against the use of English in the courts, the workplace, and the private lives of all Quebec residents, particularly English-speaking Quebecers. Civil sanctions will be onerous and crippling for individuals and businesses, from $700 to $30,000, which can be doubled and tripled up to $90,000. Bill 96 also seizes unconstitutionally federal, labor, and business jurisdictions alongside trademarks. No government contracts will be awarded to those who break the law. Even musical choice in public buildings will be subject to Bill 96. The naming of a child will be Francisized, and names of letters or characters are not used in French will be assigned a French name on their birth certificate. The search, surveillance, and seizure sections of Bill 96 are of deep concern. Hypothetical complaints by anonymous complainants can lead to a warrantless and nearly charter-free search of your premises by inspectors. Any electronic device of a client, employer, owner can be examined and searched. Firstly, the unilateral constitutional amendment declaring Quebec a nation, Quebecers a nation, and that French is the only official language of Quebec is illegitimate in form and substance. A nation of Quebec is proclaimed in two ways: to distinct Quebec people and the territory of Quebec. Our Constitution only accords powers to the provinces and federal government. The insertion of a nation into a binary jurisdictional document will lead to a distortion of the entire legal framework of our country over time. Secondly, the territorialization of Quebec language policy is a fundamental shift in the fabric of our country. Bill 96 unconstitutionally seizes federal, labor, and business jurisdictions alongside trademarks. These moves essentially displace the federal government for its own sphere of power. Though not legally required to do so, many private sector employers under federal jurisdiction have acquiesced to Bill 96, despite the administrative burden and seizure provisions and the contradictions with their responsibilities under the current Canadian Official Languages Act. Thirdly, Bill 96 introduces a new and distorted prism for human rights in Quebec and Canada, alongside the invocation of the notwithstanding clauses. The collective rights of Quebec, the Quebec nation, solely defined by the French language, are said to be balanced now with individual rights and freedoms. The notion of collective rights is heretofore unknown in Canadian and Western law. Bill 101's interpretive framework, the Quebec Charter, Civil Code, Interpretive Act, Code of Civil Procedure, all have been amended to interpret our basic private and public rights through the lens of French predominance. This will distort freedoms and human rights in ways that are not yet apparent. Fourthly, it places the pinnacle of state power, the National Assembly's arbitrary interpretation of what is required for French language protections, above the judiciary, the Constitution, the Quebec and Canadian charters, even intruding into private businesses and enterprises of 5 persons. The federal government should be deeply concerned about 3 specific aspects that are unconstitutional of Bill 96 and must protect its powers for all Canadians in the future of the Canadian state. Firstly, there are division of powers and constitutionality. The government of Quebec is attempting to seize federally regulated labor jurisdictions. As well, trademarks, not often talked about, are a federal jurisdiction in Canada. It's unconstitutional, and under the division of powers, these should not be allowed. Secondly, the delegitimization of Section 133 of the Constitution Act of 1867 ensures that all laws, regulations, courts, and the legislature function equally in English and French. This is a sacrosanct linguistic right. Bill 96's aspect, which purports to confer some unique and singular officialdom on French, is either declaratory and symbolic or of no legal force and effect. These matters are simply outside the legislative competence of the Quebec government and legislature. Thirdly, unilateral amendment to the text of the Canadian Constitution is something Canadians should all be concerned about, particularly cabinet ministers, members of parliament, and even our prime minister. Fourthly, there is a new legal status for Quebec. Lesser discussed aspects of Bill 96 include the implied restructuring of our Constitution, Quebec's legal status. Taken as a whole, the terms Quebec nation, only French-speaking state, state, parliamentary sovereignty, Parliament of Quebec, and Quebec spelled without an accent all seem to factually, legally, constitutionally, politically, and morally confirm and imply a new legal status that Quebec does not actually have. Fifthly, suppression of civil and human rights requests create, second-class citizenship for all residents of Quebec who are Canadians, after all. There will be 2 specific changes as of June 1st, 2023. As of June 1st, you won't just need your healthcare card to get services you understand. You will need to prove you are English eligible for these things, and it may be impossible to get that certification even if you qualify. You'll have to confirm your status as an English speaker with education rights to receive services from a government agency in English, including hospitals and CLSCs. While the CAC government has issued assurances that individuals can confirm on the honor system in good faith that they are deserving of a service in another language than French, as assured to us yesterday by Minister Roberts, I do not believe this is true. They've released La Politique Linguistique de l'État, draft legislations implementing Bill 96, with the language of civil administration alongside derogations on the duty of exemplarity of the civil administration and the documents drawn up or used in research. However, these three documents do not confirm the supposed ease with which people can access services. English language eligibility certificate holders will be limited to individuals who receive primary or secondary education in English in Canada. This move collapses the English-speaking community from 1.2 million people to 300,000 to 400,000 people. Only a parent can request an eligibility certificate, and many English speakers do not have a certificate if they attended school before 1977 or attended a French language school or a private unsubsidized school. Most English speakers over the age of 60 will not have the certificate, and if their parents have passed away, cannot legally request a certificate of eligibility. This will penalize the oldest, sickest, and most unilingual members of our society who need assistance and understanding most of all. Newcomers, new Canadians, whether arriving 3 months or 30 years ago, will not be permitted to communicate and receive services in the government in a language other than French for more than 6 months. After that time, they will no longer be able to communicate or receive services in a language other than French. Bill 96 additionally needs to be seen in the light of other legislation. And I think this is often lacking in the interpretation of what is really going on in Quebec and Canada with the full acquiescence, knowledge, and complicity of the federal government. Bills 21, Bill 40, the Oath Amendment, the little-known May 2019 agreement concerning Supreme Court justices from Quebec. These laws suppress fundamental and religious freedoms, eliminate English language school boards, which are constitutionally guaranteed, and amend the constitutionally required acts to sit in our legislature and allows Quebec to choose Supreme Court justices. Quebec is being carved out of Canadian Federation. Wait until Bill 2196 gets to the Supreme Court is a common refrain I hear from commentators, activists, and lawyers. However, I believe they are wrong. The Supreme Court will not save us. The notwithstanding clause, even evoked before a judgment, is valid in Canadian law and shields much of 96 and 21 for judicial scrutiny. There are, of course, educational, gender, and jurisdictional rights that are likely to be upheld by courts of law. However, since 2019, the Quebec Minister of Justice and the Premier of Quebec formally helped choose Supreme Court Justice from Quebec. Yes, Nicholas Casseur, a former McGill law dean, was appointed to the Supreme Court in 2019, and he was approved personally by François Legault. However, we can choose to save ourselves as Canadians. Did you know that until June 1st, 2023, the federal government has the right to disallow Bill 96, essentially nullifying the law? Yes, Bill 96 can cease to exist in a legitimate way. Nothing short of a preemptive strike against this illegitimate, immoral law by the federal government is needed to reassure Quebecers that minority rights, socioeconomic justice, and linguistic harmony still count for something in Canada. Nothing short of a preemptive strike against this, it is imperative that the Government of Canada use both the legal means and financial leverage at its disposal of this most solemn duty to protect Canadians. The party requests the following actions be taken. Firstly, demand the Government of Quebec uphold accessibility obligations, information requirements, and all access to care provisions stipulated in the Canada Health Act in order to continue to satisfy criteria for receiving the Canada Health Transfer, over $10 billion on an annual basis. Secondly, render public an unredacted legal analysis of Bill 96, which David Lametti, our Minister of Justice, claims to have had since May 2021. Thirdly, to speak out forcefully against Bill 96 flagrantly unconstitutional articles. Fourthly, initiate a reference case on the constitutionality of Bill 96 as a whole to the Supreme Court of Canada, including analysis of chapters and sections shielded by the notwithstanding clauses. A Canadian Charter of Rights and Freedom Section 1 application to the notwithstanding clause should also be tested. Fifthly, in consideration of all the above, and in the event the Supreme Court of Canada is unable within 1 month to render judgments on the reference questions submitted, signal immediately the Government of Canada's intention to use disallowance to protect the province's most vulnerable residents if the Quebec government refuses to voluntarily rescind Bill 96. Sixthly, in consideration of all the above, the Government of Canada, members of Parliament, cabinet ministers should disallow Bill 96 in entirety before June 1st, 2023. Thank you.
Across Canada, access to healthcare services and professionals is at an all-time low. In Quebec, however, the access problem is worsened by the passing of Bill 96. Sold as a law to protect and promote French, in practice, Bill 96 effectively eradicates the presence of English in public and private sectors of business, education, and health. Bill 96 is in clear violation of the Canadian Charter of Rights. The chronic use of the notwithstanding clause by the Quebec government has allowed for the current specific assault on the rights of Quebecers to obtain access to health services and professionals. Initially, Anglophone Quebecers were told they would continue to have access to English public services, provided they could prove their status as a historic Anglophone. Recently, the requirement of proof was walked back, and we are now to believe that the honour system will prevail. Nowhere else in the world is the provision of health services potentially prohibited to occur in a patient's language. Bill 96 forces professionals and patients to interact in ways that are completely artificial, affecting quality of care. 4 ways that Bill 96 damages the provision of healthcare services. 1. Compromised access rights. Under Bill 96, access to English services is not guaranteed. The language of the workplace still remains French. 2. Training and education of healthcare professionals. Bill 96 limits access to English post-secondary education. By limiting the number of students who enroll and graduate, Bill 96 limits the number of medical professionals in the field. Bill 96 fundamentally changes the post-secondary curriculum. Focusing on the acquisition of French proficiency comes at the cost of learning core material. 3. Systemic discriminatory practices against professionals. Failing to hire competent professionals in the public sector who do not meet French language requirements. Bill 96 requires discriminatory hiring and promotion practices around linguistic variables, regardless of professional expertise or competence. Penalizing professionals for making linguistic accommodations to better treat patients. If found to be in breach of Bill 96, professional healthcare workers could be fined. 4. Systemic discriminatory practices against patients. Increasing occurrence of discriminatory practices against vulnerable minority groups. Under Bill 96, malpractice could occur. Some of the most vulnerable Canadians, such as the elderly and mentally disabled, will be misdiagnosed and treated because they cannot function in French. Breaches of confidentiality. An investigation by the OQLF allows the search and seizure of documents without a warrant. Agents of the OQLF will have access to confidential documents and patient files. Today, we'd like to appeal to the federal authorities. The Canadian government has the right and the responsibility to disallow the abusive use of the notwithstanding clause and prevent the passing of unconstitutional provincial laws. The federal government has the right and the responsibility to make transfer payments contingent upon offering diversity of services, making provinces accountable for all types of diversity, linguistic, religious, racial, at all levels of healthcare, including education, hiring, training, service provision, recruitment, and management. The federal government must disallow Bill 96 while they still can. Time is running out. Citizens should never have to fear that they will be required to prove their right to receive English services. This is a breach of fundamental human rights. Thank you.
Excellent. Thank you, Myrtis. And my apologies for not introducing her previously. Myrtis is a psychologist, was a former candidate for the Canadian Party of Quebec in Saint Laurent, and sits on our executive committee. As well, to our far left is Keith Henderson, former leader of the Equality Party, provincial party in Quebec. To my right is Will Tulin from our candidate in Pontiac in the recent provincial election. Will is currently a student at the University of Ottawa. So thank you very much for being here today. If there's any questions from the media and audience that are assembled today. Thank you. Great. Okay. Excellent. Thank you.